This is a presentation on cybersecurity laws in Cyber 220. Let's get started here. We're going to be talking about how the digital age has affected laws related to intellectual property. Now we're going to talk about um, what types of intellectual property need protection. Um, and we're also going to be talking about cybersecurity laws that need to be enforced and who will be enforcing them. So the All Writs Act is a very flexible act. It gives courts the jurisdiction to close cases how they see fit. Um, and this can be really useful for the ever-changing technology field, in which um, is always growing, always changing. A good example of this is using the Fifth Amendment to protect phone screens from or phones from being unlocked through unwarranted searches, even though they're not like houses or private property per se in that sense. Um, it's still considered it still needs a warrant because it's still considered private property, and law enforcement would be searching those in present day for evidence in cyber laws. Next, we're going to be talking about intellectual property. This is anything that's defined as distinguishability between brands. This can be anything from trade secrets, mascots, logos, and literary works. And oftentimes, this is the competitive advantage for a lot of businesses, like the trade secrets for Olive Garden's breadsticks or the recipe for Coca-Cola, stuff like that. So we're going to be talking about patent law now. Patent law protects invention and original ideas. This encourages people to make new inventions and concepts. And while patent law is in effect, the originator of that invention actually gets a monopoly for a temporary period of time where no one else can copy that idea. And this may seem very backwards to a lot of people at first, like how are monopolies, illegal? But this actually makes a lot of sense because how would you feel if like you made a new invention and then someone ripped off your invention and started profiting off of it and undercutting you? That would not there would not be very good incentive to make an invention, essentially. But that monopoly does run out after a certain period of time, and after that patent is used up, people can use that idea that you have originated. So that is patent law. Now we're going to move on to trademark. Trademark is can be logos or mascots or anything like that, or the name of a business. And this can be really useful for businesses to build reputation. A good example of this, a really good example of this, is McDonald's Golden Arches, which really helps McDonald's stand out, and it builds that rapport between consumer and business. If and the consumer knows that when they see the golden arches of McDonald's, they know exactly what they're gonna get. They're gonna get McDonald's, not like Mr. Burger or some other brand, some other offshoot of a burger joint. Um, and yeah, trademark can really help differentiate those brands from one another. Now we're gonna move on to copyright. Copyright is basically any artistic expression in physical form. This can be music, books, film, choreography, and art. Um, and typically, you don't need a to apply for a copyright. a copyright is pretty much enacted when you publish that artistic work, and this can help a lot of businesses and a lot of individual creators to basically protect their ideas from being profited off of from other people. Um, and typically, this lasts many years after an author's death, um, just to give them enough time to profit off their intellectual property long after their death as well. Now we're going to move on to the United States versus Ivanov. So Ivanov, this is a case in which there was a lot of scrutiny between how cybersecurity laws should be enforced. Ivanov accessed credit card information from American users while he was physically in Russia. Eventually, Ivanov was found guilty under the Computer Fraud and Abuse Act. They, the courts eventually said that because Ivanov's actions affected American users and if it affected people on American soil, that he should be tried in America, and he was eventually found guilty. And now we're going to talk about infringement on cybersecurity laws. A lot of the time, cybersecurity laws protect businesses, very large businesses, but this isn't innately a bad thing, as it does help consumers differentiate brands and businesses and all those products that they love. It also like a lot of cybersecurity laws protect from digital private piracy, profiting off of other people's intellectual property, and encouraging people to come up with their own original creations. So not at all a bad thing. And Universal Studios v. Corley. This was a case in which Corley essentially made decryption keys for DVD content, um, which the DVD content was encrypted and was legally encrypted um, under the Digital Millennium Copyright Act or DMCA. Um, and actually, the very interesting thing about this case is that Corley's actions were protected under the First Amendment rights. He said that computer code was protected under free speech, and as a result, the courts issued a permanent injunction on Corley to have him stop posting decryption keys for DVD content, and but he was not found guilty or punished for the code that he's already put out, if that makes sense. And these are the references that I used.